Roxborough, Massachusetts. It's a commercial office building. There's about 12 tenants, and there's a parking lot. And my client bought an insurance policy for that building in the parking lot. The policy is located in the appendix at pages 107 through 172. It's a 65-page policy. And like a lot of insurance policies, it's essentially an all-risks insurance policy with respect to direct physical losses of the type that occurred in this case. What that means is that it covers everything unless an event is specifically excluded. One of these specific exclusions in the basic policy was for water damage, and that exclusion is located at page 122 of the appendix. But my client in this case paid extra money for an endorsement to the policy, an amendment to the policy. And the endorsement specifically and affirmatively included coverage for water that backs up from a drain, and thereby created an exception to the water exclusion.
Well, does it create an exception to the whole water exclusion or just subparagraph 3 of the water exclusion?
That is part of the ambiguity, Your Honor. What the endorsement did was it took this language, this drain backup coverage, which was purchased at extra cost, and it jammed it right into the water exclusion, right in the middle of the water exclusion. And so we have a variety of words that are used to describe water. Surface water is one of the phrases. Mudslides is one of the words. Tides, water that's blown by wind. And then we had water backed up from a drain. What the endorsement did is it deleted water backed up from a drain as part of this comprehensive definition of water. And it simply inserted this language that said, we will pay up to $25,000 for water due to a drain backup. And there was no indication as to the interplay between this added coverage inserted right into the middle of this exclusion and any of the other words used to describe water. No indication of the interplay between this added extra cost coverage and the anti-concurrent cause provision on which NGM relies. There was no reference in the endorsement to the anti-concurrent cause provision. And the anti-concurrent cause provision says if an exclusion applies, then it doesn't matter that there's some other event that also caused the damage. Well, the extra cost coverage created an exception to the water exclusion. And so we have, number one, the argument about the ambiguity created by the lack of clarity with respect to the continuing role that this anti-concurrent cause provision plays with respect to the new coverage. And number two, we have the question of whether surface water was even involved in this case. If surface water has a separate, independent meaning from water that backs up from a drain, and it has to, because you interpret insurance words to have separate and independent meanings.
But under the exclusion before the endorsement was added to the policy, I take it drain water or damage caused by drain water backup was excluded from coverage.
That's right, Your Honor, because it was part of a...
Regardless of whether you call it surface water, water that lost its feature as surface water because now it was channeled into a drain or whatever, anything that backed out of a drain was excluded.
That's right, Your Honor.
And then the endorsement changed that.
That's right.
What's ambiguous about that?
What's ambiguous is we don't know. It's unclear whether this is creating an exception to the exclusion, as I would say it is, or whether the anti-concurrent cause provision applies, and then you look to the other terms in the water definition. What we had here was a comprehensive exclusion of water, all water. And they used, and their claims manager testified at his deposition, they basically used every word they could think of to describe water, because water is excluded in the basic policy.
But let me back up for a second. I need a little help here, because I'm a little surprised that you're saying that it's an ambiguity. It strikes me as being perfectly clear what was intended, but I'm missing something, and it has to do with the anti-concurrent language.
So if the surface water was connected to this loss, in other words, if the drain backed up and the surface water then seeped into the building, then the argument would be that the anti-concurrent clause would bar coverage, right?
That's NGM's argument. It's an
right.
argument that was rejected by the Bishop's case in Pennsylvania, which
Right.
examined...
But in terms of the ambiguity, that's where it comes from, I think.
That's part of the ambiguity, Your Honor, but part of the ambiguity, too, there's really two sources of ambiguity. The other source of the ambiguity is that surface water, if you take the expansive definition that the defendant wants, is always involved in water backing up from a drain. And we say it can't be surface water.
Actually
in this case.
not.
Well, no,
Not-
not in the
necessary.
house.
I mean, if you're in a house, you've got a drain in the basement, your washer overflows and the water, the drain's backed up and the water, I mean, there are in-house drains that have nothing to do with surface water.
That's right, Your Honor, and we can imagine some circumstances, but that's not what the policy language said. The policy language said water backs up from a drain, sewer, or sump, and there was no indication if NGM intended for this to only cover interior drains, or if they intended it to only cover when a water main blows up, they should have said that, and they didn't. And when we asked the claims consultant, the claims manager for NGM at his deposition, have you paid out on claims where this endorsement was involved, but there wasn't surface water? He said yes, and he said heavy rains were involved. Now, he later submitted an affidavit because they were worried about the way that deposition testimony looked. But in his affidavit, he says, well, it was interior drains, but there was still heavy rains involved. So how, if you take this expansive definition of surface water, do you say that there was no surface water involved? And if you look at any definition of surface water that's been used, whether it's in Massachusetts, or whether it's in Pennsylvania, or whether it's in Louisiana, as one of the cases that my brother cites, it refers to naturally spreading over the ground. Diffusing over the ground through natural drainage is actually the language that the Cochran case from Louisiana uses. And that's referenced on page 11 of the defendant's brief.
What Massachusetts seems to use is the restatement second language.
As interpreted through De Sanctis, yes, Your Honor. And that uses the language naturally spreading over the ground. There was no natural spreading over the ground in this case. There was no natural drainage because we had a drain backup. And the parties essentially agree, it's undisputed, that the source of the damage was the drain backup. There would have been no damage if the water had all gone down the drain. That's what the drain is for. And I would like to draw your attention to...
So, I'm sorry, so is the issue that we should narrow our definition of surface water?
The issue is that we should construe surface water so as not to render coverage for drain backups meaningless.
So one way to look at this then is to say that the endorsement insured against damage from surface water that had backed up from a drain.
That's absolutely right, Your Honor. That's one way to characterize it. Another way that we would say it is that it lost its character as surface water. If it ever was, when it fell from the sky, surface water, it lost its character as surface water when it was diverted as a result of the drain backup. We agree that without the drain backup, there's no damage to my client's property.
So I'm trying to figure. So it's raining hard. The drain is stuffed. When it falls to the ground, you say it's surface water. But it no longer becomes surface water if it's carried because of the drain backup. I'm trying to figure how we distinguish between this water which has just fallen from the sky.
We don't concede that it's necessarily surface water as it falls from the sky, but surface water is water that spreads or diffuses naturally, and that didn't happen.
Oh, I see.
It did it unnaturally because of a backed-up drain.
Or as soon as it was channeled into the drain, it was no longer surface water.
But it wasn't channeled in was the problem, because the drain was filled, right?
Well, we don't know when the drain was filled, and that's another point here. The parties concede it's impossible to know when the drain became clogged. It's impossible to know exactly how much water went into the drain and came back out versus how much water just traveled over the top of the drain.
Is the insurance company saying that under the endorsement, the only conceivable damages that you could have was the damages caused by the amount of water that would fill the drain pipe?
They seem to be arguing that, although they're also essentially saying that you're only covered for interior drain backups and you're only covered when a water main blows up, or I suppose if a polar water beverage delivery truck collapsed and the polar water went into the drain and came back out and damaged my client's property, then it would be covered. But they're saying that when you have a heavy rainstorm and the drain backs up, you're not covered. You're not covered because of this anti-concurrent cause provision that we didn't tell you about in the endorsement, and that says it applies to an exclusion, but does it apply to an exception to the exclusion?
Well, isn't it, if I get these shifting burdens right, it's your burden to show that it's an exception to an exclusion, right? To prove that it's an exception to.
I disagree, Your Honor, because I believe that, well, first of all, this is an all risks policy. So the idea is that we have coverage, and then they have to find an exclusion. Once they find an exclusion.
And they have to prove the exclusion, but I thought the insured had to prove the exception to the exclusion. But maybe I'm wrong.
Well, I think in order to prove the exclusion, you have to prove that the exception doesn't apply. And what the Bishop's case said is that the burden is on the insurer to make it absolutely clear that the anti-concurrent cause language applies to new extra cost language inserted as the result of an endorsement. That was the real issue in Bishop's.
How important, if at all, is it that you paid extra for this gold endorsement? Would it matter if this were simply part of the policy itself?
It's very important, Your Honor. If you pay more, you should get more. And one of the few coverages, in fact, really the only affirmative coverages in the endorsement is this coverage that my client paid extra for. And that was the issue in Bishop's. That's why Bishop's distinguished itself from Front Row Theater, on which my brother relies. Front Row Theater didn't have an extra cost endorsement. It was simply an anti-concurrent cause provision being applied against coverage in the basic policy. Here we have this universe of everything's covered, and we don't have these specific coverages. We have specific exclusions. But now we have specific coverage that's being added as the result of an extra cost endorsement, and it's being inserted right into the middle of an exclusion. That's unclear. All that we ask is that you insist on clarity in insurance policies. And if you do that, we're going to have fewer insurance policy interpretation cases coming before you. But
you don't disagree, I take it, that the $25,000 limit applies. I mean, if you prevail, that's the limit of insurance that you can get. I understand your bills are under that, but right?
Absolutely, Your Honor. The $25,000 limit applies. And they could have put the coverage into the limitation section for that reason. There's a limitation section in the policy, but they didn't do that. The bottom line, I think, is we have this policy construction that...
But we say, I mean, we have said that, or there have been cases that have said that if there's any benefit at all provided, then that's sufficient. Am I wrong about that? I mean, here there are. I mean, sink drains clog and back up. There are all kinds of drains that can clog and back up, having nothing to do with surface water. So it's not like that's totally inconceivable.
But it has to be clear, Your Honor, what is the benefit that's being provided. And it's not the burden on my insured to try to interpret the policy by looking through 65 pages and reading some case law and trying to imagine what could I possibly be covered for. It says drain backups, but I bet that's limited to interior drains. And what we have is policy language identical to in Bishop's, very similar situation in the Boazova case that you're about to hear. And we had my client's agent. We had an appellate court in Pennsylvania. We had 2 justices of the Massachusetts Appeals Court interpreting the language one way. And we have the trial court in my case and the 3 justices of the Mass Appeals Court interpreting the language another way. That's the definition of ambiguity, I would suggest, where you have reasonable people disagreeing on what the language means. And I thank you very much for the opportunity.
Thank you.
Good morning, Your Honors. My name is David Hassett. I represent NGM along with co-counsel Scott Ober. We would ask this court to affirm the trial court judgment and declare that there is no obligation to indemnify Surabian, and further that there is no coverage afforded under this business owner's policy. I think the crux to the issue, as my brother described it, is two events or two phenomena that he simply is not incorporating into his argument, and I think that's why at the very outset the argument fails. In this case, you have a rainstorm, undisputed, heavy rains, undisputed. The record before you demonstrates that one of the tenants was there, and within half an hour, the water stopped, the rainfall, the surface water stopped entering the drain, stopped going down the drain, and began flowing into the building. She called the owner. She then was told to call the fire department. The fire department took another half an hour to get there. The fire department came over. It was still raining when the fire department came over. They then called the Mass Department of Public Works to get a sump pump. They were there till 10 o'clock at night. She anticipated or guessed that she first saw the rain stop between 11 and 1 p.m.
So are you contesting that the rain backup, that the drain backup didn't cause this?
No, Judge, it is a cause, but my brother seems to be going back to an analysis.
If the drain wasn't backed up, there wouldn't be a case, would there? Wouldn't all the water have flown?
If the drain didn't back up, there may have been no damage, but there certainly wouldn't have been any damage if there wasn't a heavy rainfall.
You're talking about the anti-concurrent
Yes,
provision.
precisely.
And you're saying that that governs here because there are these two phenomena. And so what you're asking us to decide is that the endorsement was an exception to the exception doesn't mean anything because it really, it also incorporates the anti-concurrent clause.
Absolutely, Your Honor. It incorporates the anti-concurrent cause
And
language.
You're saying that's very clear. You have to be saying that.
I am saying that, Your Honor. And by the way, this is a 4-page endorsement that carries many other additional benefits.
Right. So make it clear to me why the anti-concurrent clause is also applicable to an exception, to the exception.
Because, Your Honor, in this case, the endorsement just deletes paragraph 3. And paragraph 3 that you have before you is that there's the water.
And it changes the language. I mean, it doesn't, it takes out 3 and it replaces it, and it specifically says, we will pay for, which is not part of what is in G at all, that kind of thing.
Well, actually, Your Honor, at the bottom it says, but if water as described in B1, G1 through 4 results in explosion, sprinkler leakage, we will pay for loss of damage caused by that fire explosion or sprinkler leakage. So I think what it's doing in essence is suggesting that we are going to cover certain overflows or backups from sumps or sewers or drains, but that we're going to limit it to the $25,000. But you go back to the anti-concurrent language, which is the preamble to the exclusion in B, and it specifically says that such loss of damage is excluded, the water damage, regardless of any other cause or event. The other cause or event in our case is the potential that some of the water that entered the drain may have indeed also have overflowed, however slightly, and also entered the building. But it's very, very clear that 2 days later, when the drain is inspected, it's full. Several days thereafter, they determine it is debris. So as one of your honors had indicated, it's clearly a blocked drain. It's not working. This isn't water that came from and overflowed from a drain.
Are you arguing that, let me just get that clear, without the anti-concurrent clause, are you saying there would be no liability under the endorsement, or there would be? If you didn't have that,
I think it's factual, Your Honor, but in our
it would be
case,
for a jury to decide.
I think there would have been a
Okay.
question as to whether or not, the language is very clear, that what's contemplated is water overflowing or coming from a drain. And some of the jurisdictions we
Well,
quoted.
it went down the drain for half an hour, and then it stopped. So-
What we envision, Your Honor, is this drain fills up and it doesn't drain off the property because it's blocked with debris, and then it fills, and then the rainwater thereafter flows naturally following the surface on the parking lot and ultimately into the building. So you have
Let me just ask you a background question that's been nagging at me. Is this water that was started on the roof, got channeled from a drain, a horizontal drain, went down a downspout?
No, Your Honor.
Where did the water first hit?
The water hit the area around the building. It's a commercial 3-story
Yeah.
building. They hit a parking lot. There's a parking lot in the front. There's a parking lot in the rear. In the rear, there is a drain about 20 feet from the building, and the water hit the parking lot surface. It was very, very intense, heavy rain.
So if this drain did not exist, you're saying that there would have been surface water damage inevitably?
Absolutely, Your Honor, because what happened is the drain wasn't doing anything at some point after it filled up.
This is not a case where an underground drain pipe, for some reason, as a result of blockage in the underground storm drain system, caused water to back up and flow into
No.
the insured's house or building.
No, but
Not at all.
if the drain were working, I think you said, if the drain were working, then presumably the water wouldn't have, it would have gone down the drain, right?
And we've accepted that, Your Honor, and we've accepted under the anti-concurrent cause language that you could indeed have a cause, this cause being water from a drain or sewer, but you can't have another uncovered cause. And the way the jurisdictions have analyzed it is fairly straightforward. You got two events. Nobody can argue that there are two events here. There is a very heavy, intense rainstorm for a period of time, and there is a drain that's not functioning properly. We had conceded for purposes of summary judgment that it's arguable that some of the water in that drain overflowed, however very little, and also contributed to the ultimate damage at the building. But you can't eliminate the uncovered component of the damage, which is the rainfall, which is the surface water.
Does it
All right,
matter
this-
at
Can you
all?
tell me, what was it that the plaintiffs paid for extra coverage for?
Yes, Your Honor. Your Honor, it's a 4-page endorsement. It's in front of you. It's as part of the record. And it covers, it extends coverage in many other areas. It's a business owner's policy that were issued. It's issued with the policy. It's not something he says 3 months later, by the way, I think
Extra
I'll
for
add it.
But he paid extra for it.
He paid extra for it, Your Honor, and he gets additional coverages. I think it's on page 168 of the record. You'll see there's lock replacement, fine arts, off-premises building, business income from dependent properties. There's a series of additional areas.
The one that applies here reads what?
The one that applies here is G, water backup. It's on page 171, and it states, the most we will pay for loss or damage caused by water that backs up or overflows from a sewer, drain, or sump is $25,000. So that was included among other things. And
But you're saying that this is not water that came from the drain. The drain stopped working. This is water this was surface water that had nowhere else to go except into the guy's house.
I am saying that, Your Honor, but I am conceding that some of the
it.
water could arguably have come from
The drain.
the drain when it overflowed, if so little that potentially got in. And we're conceding that based on the clear language in the exclusion, as long as there's the uncovered event,
So is there any limited coverage here?
limited
Partial-
beyond...
part-
No, that's excluded. The rainwater damage is excluded.
Excluded
The flood is
altogether.
damaged. Yes.
So if I'm concerned that my sump pump may fail, I purchase this coverage, correct?
Yes.
But the sump pump fails only when there's melting snow or there's heavy rain, so I get nothing.
I disagree with that, Your Honor.
Well, what do I get if
respectfully.
my sump pump fails? How can I possibly get anything from this extra coverage that I paid for?
Because based on the sump pump design, you've got a hole literally in your basement. And if your sump pump fails, there are instances where as long as the water goes through the sump pump, like backs up a drain, then you would have coverage.
Notwithstanding, this at one point in time was surface water because it rained.
Correct,
Rain went
absolutely.
into the ground.
Yes.
The sump pump failed. The water
If
came
it
back
comes
up through the sump.
you
That's
would.
covered. Even though surface water, an overabundance of surface water was a cause.
That's correct, because it's no longer characterized as surface water once it goes through the pipes underground.
And I'm supposed to read this policy and know that?
Figure that out?
Well, Your Honor,
And a drain doesn't work the same way. A drain, things go down, they don't come up.
well, I think it's inclusive, Your Honor, in terms of a sewer or a storm drain, a sewer or a sump. A drain typically you would not expect, but you could get a backflow in a drain in a house. Could be a plumbing failure.
Why don't
could
you
be a
say
high water.
house if that's
Excuse
what
me,
you
Your
mean?
Honor.
Why don't you say house if that's what you mean?
Well, Your Honor, I
Interior
think as
drains.
long as there's coverage, under McGregor, I think the standard, I think Justice Cordy mentioned it, was that as long as there is an identifiable coverage being offered, it doesn't have to cover every event. And I would suggest here that the cause being the heavy, heavy rainfall is the issue in this case. If the water came back out that drain in the parking lot by way of a water main break, which really is not too
I
uncommon
understand
today.
your point. My real question is, are any of the cases you cite, do they deal with this kind of situation in that it's an endorsement that provides the exception? and
Yes,
that you're applying- Okay.
Doylestown does, Your Honor, and
Right.
Mantanaro. In the
Doylestown is a,
Pennsylvania case, it's 1996. I've got the site, Doylestown Electric.
It's in your
It's in your brief.
It's in the brief.
I see where it
In the Mantanaro case,
So,
does,
so what's your burden? You have to prove that the exclusion applies.
correct?
Do you also have to show that the exception to the exclusion does not apply?
Judge, I'm not finding the analysis as going that far in terms of an exception. I'm
You're
reading.
doing the concurrent, the anti-concurrent.
I'm going strictly with the anti-concurrent. And I would point out, Your Honor, in the cases that we've briefed, they have dealt with this very same policy language. They've dealt with the very same anti-concurrent language. I will note that the Bishop's case relied on by my brother is not persuasive or compelling at all. The court states in that case that they disfavor anti-concurrent cause language. This court has already stated and put its imprimatur under JUSM for this very language when an insurer intends to not have something covered. And in the JUSM case, where this language was lacking, we went to a train of events analysis, which I submit is essentially what my brother is arguing, and he's trying to state, but for the drain, this would not have happened. This should be covered. Here, with this language, we've got two phenomena occurring, and the language clearly states when one of them is not covered, covered event, uncovered event, as long as one is not covered, there is no coverage for that damage. In the cases, the Front Row Theater case, the Hirschfield case, in the Front Row Theater case, which is particularly instructive, they literally had two levels of different drainage. And on the top level, it was supposed to drain to another set of drains and then go off the property. In that case, they identified the fact that some of the water went right over the drain into the building, some of the water went through the first series of drains, but not the second because of the clog, and they identified the fact that clearly we have two different types of water, two phenomena. One literally came out of the drain, the other came from the rainfall, and coverage was declined.
but you're actually conceding the point for the summary judgment that some of the water did come out and was separate.
Yes, Your Honor.
Okay, so that's sort of not relevant to this case.
All right, I think I finally understand, but just to be clear, this is why I hire an agent. This is why anyone who thinks they can understand these on their own is running serious risk. The sewer backups are frequently caused by rains, heavy rains. They leak into the sewer systems, they overflow, they overburden the systems, and sewers back up. Whole neighborhoods have been wiped out from such things. I take it you would say, no, that's covered, because if it's coming out of your sewer drain, no matter whether it was natural water that entered the sewer system, if it comes out of your drain, it's covered.
Yes,
And
Your
no
Honor.
anti-concurrent stuff
Yes, Your
applies,
Honor.
even though there was rain that caused the whole thing.
Its character has changed.
Okay, I understand that.
Well, but
Thank you, Counsel. Oh, excuse me, do you
I'm
have?
sorry, I guess I'm just, even in that indication, you say that, and it's helpful in this case, but it seems to me if you're really depending on the anti-concurrent language, you could say that the loss or damage is regardless, it's indirectly caused by the rain, couldn't you?
You could, Your Honor, and I
And an
think...
insurer would, in
I
the
think
right
that,
case?
I think it's a little different argument, because you could, if you use the direct or indirect analysis, you can basically expand it even beyond the two phenomena and beyond the idea that surface water...
Just looking at the language of the anti-concurrent clause, which says caused directly or indirectly by any of the following.
Yes, Your Honor. I think the Georgia Court in Hirschfield did just that, but what we've looked at is what, based on the two phenomena that happened here, we were saying that the overflow from the sewer would be covered were that all that occurred. Here, we have also the surface water from the rain, and we're simply concluding that because of that and because of the clear language, there is no coverage for the damage that ensued.
I think we'll leave it there. Thank you very much.
Thank you very much.
We'll take a brief recess.